number 172, Flo and Eddie Incorporated versus Sirius XM Radio Incorporated. Chief Judge Stu Fiore has recused herself from this case, so we have a six-judge panel. Mr. Hacker, good afternoon, sir.
Good afternoon, Your Honors, and may it please the Court. Plaintiff asked this Court, I'd like to reserve 5 minutes for rebuttal, if that's okay. Thank you. Plaintiff asked this Court to create or recognize a right that, as the Federal District Court observed, would be unprecedented and would have, quote, profound economic consequences for the recording industry, quote, upsetting settled expectations for traditional radio broadcasters and upending both the analog and digital broadcast
Very
industries.
interesting to me, this trying to figure out all that we're talking about here. But as I understand it, if you play Pearl Jam, you got to pay them. If you play the Platters, you don't.
That's the consequence of the dual regime for
Right.
post-1972 and pre-1972.
I'm focused now.
Yes. That is the difference.
What is the economic impact? Would it be that if we decided in favor of Flo and Eddie, as the district court had, and said that we should answer that question, yes, would that mean that now recordings that are played before that were made before 1971 would be paid, what, in the same way that the 1972 and forward would be, or?
Not at all. We don't know at all what would happen.
know
All
what
it would
would
do
happen.
is give record companies the authority to prohibit the performance of those records that were made before 1972.
Without some sort of payment?
Without some sort of payment that they would have to negotiate, that would have to be negotiated with every single record company and record owner, which isn't just the four that there's already one settlement
Their
with.
advantage too, right? They want it played. Isn't that
Record
beneficial to
companies.
them? They want it played because then they'll get money off of you playing it.
They might, but we don't know what exactly they would demand in terms of a license. We don't know how all of those who broadcast, which includes not just Sirius XM, but all the radio
Because
stations.
it's all about our common laws. Isn't our common law, isn't that what our cases say? Flexible, we respond to changes, and these are, I think, both sides agree, and there's no way you cannot agree, that we're talking about a very different world technologically than the world of the Platters or anyone else from that time period. And doesn't our common law have the flexibility to respond to that?
There's flexibility, but there are clearly limits, and there's a couple of points I'd like to make on that. The first is, with respect to Sirius XM, we're not actually talking about a fundamental technological change. Sirius XM is just another way of providing radio.
Well, and
radio stations were around for decades.
That's a good point, I think, because in many ways I think that goes to one of the more interesting parts of this appeal. It seems, in my mind, we have four formats that we're dealing with here. First, we have traditional radio. Secondly, you have internet radio. In both of those formats, and let's call Sirius XM, even though it's in cars and everywhere else, it's a streaming service. But the listener does not choose what to listen to. They don't own what to listen to.
Correct.
Then we move to the next level. Like me, I buy CDs still, and you buy CDs or a record. Those are owning a hard copy of it, and I can play that anytime I want. But now, every one of those first three formats are addressed and covered, it seems to me, by both statute and history. But now we have a new format where, in essence, whether you have Apple Music or Spotify, whatever you're doing, you're renting music. And when you rent music, then you can listen to it anytime you want, just like you have a hard copy. It's not random. You own it as long as you pay your rental fee, just like I can use the space in my apartment as long as I pay my rental fee. So in that format, in that last type, I'm wondering why the owner of that copyright wouldn't have some rights to this new form of musical listening, and that involves a rented ownership, as opposed to the other formats, which you're in a different situation there.
Well, much to say, if I understand the question right, the owner of the copyright in the underlying composition does have rights in that last type of format, but also the fact that you've correctly, I think, identified the different kinds of technological formats, and the fact that they raise different concerns, economic, policy, competing policy interests, tells us why.
They do, but the
this
problem
a
is, you know, there's two approaches to take care of. As one of my colleagues said, eloquently, I thought either it's a legislative question or it's a common law question. So if it's a common law question, does the common law respond to this kind of fundamental change in the business or not, or do we say it's a legislative question?
Well, I think it's a legislative question in part because the common law, this court does not have the tools before it that are necessary to do all of the work one would have to do to recognize and create, enforce, implement, and administer this right. Just like in the Coronia case, the court said there was no framework available to recognize a medical monitoring
Are there any
claim.
jurisdictions in which this right of performance has been recognized and is currently recognized under common law?
Not one. It doesn't exist. The only place it exists is under the Federal Copyright Act, the DPRA, which only did it after years of study by the Copyright Office, 2 years of study, a 1,000-page report balancing all of the competing interests.
The fact that they haven't gone out and sought it before doesn't mean it doesn't exist, right? Doesn't mean that the common law might not yet recognize it. Isn't
Well,
that the point? That we're now at the point.
I think it does in the following sense. This court emphasized in Naxos that in this area in particular, a page of history is worth a volume of logic. For decades, Your Honors, radio stations have been playing records that they lawfully purchased with no objection from any
Let's talk about the
stakeholder.
page of history. What about Metropolitan Opera? Isn't that a recognition of some form of a performance right that is not given up merely by giving someone a record, selling a record?
Two answers. One, I don't think it is the copying case. It's not about recognizing and allowing somebody to control post-sale performance. And back to the page of history point, nobody, zero, courts, industry stakeholders, commentators have ever construed Metropolitan Opera as
I
creating that.
understand, but so we're trying to construe it, right? So where is the language so narrow that it would not let us say that there is at least some seed in Metropolitan Opera about this performance right that's going back to 1950?
Well, I don't know that it's a question of the particular language in Metropolitan Opera. If the court wanted to create this and be literally the first court in this jurisdiction or any other
I'm not
to
talking
do
about
it,
creating it. I'm talking about sort of this common law, right? Yes, I started out that place. I'm just asking about this particular case. And doesn't this particular case have, so it's not our case, granted, but some
Yes.
interesting language about a right of performance and why that's not necessarily given up? I think, I'd especially like you to address this question of, I think it has in here, a limited publication for limited purposes on that right of performance. Isn't that perhaps what we're talking about here? A limited publication for purposes of allowing people to play it, but if you're going to go around profiting off of it in the way that you do, they say, well, wait a minute, that's not what we intended to give up when we sold off the CDs or we allowed you to play it.
Your Honor, we all grew up with Wolfman Jack, listening to the radio. All of those
Some of us are younger
broadcasters
than
profited.
others, may I just say, but go
What?
right
I'm sorry,
ahead.
counsel?
They all profited.
Oh, they all profited?
Those broadcasters have been profiting for decades.
Mr. Hacker, you mentioned that we don't have the tools to do it, and I was curious if you could outline that a little bit.
Okay.
And I get your medical monitoring.
Right, and the framework, the only analog we have, again, no jurisdiction has done this as a matter of common law. This court has only recognized an anti-piracy right, which is very limited, just preventing copying. What you have in the DPRA is a very nuanced scheme, regulatory scheme developed after a long period of review with competing policy interests. And remember, there's competing interests here. Consumers will be worse off. Performing artists will be worse off. Composers definitely worse off. And here's how the DPRA deals with it. They have a number of different regulatory, a nuanced structure to manage it. There's a carve-out for terrestrial broadcasters, so radio can continue to do it, as they've been doing for decades. There's a compulsory licensing scheme, so that you can't just stop it. You can't just say no or demand a confiscatory amount.
Hypothetically, if we said that there was this limited common law right and it pertains under the change in times to these companies that actually rent or sell the right to listen to music, how would we decide who was profiting from it? For example, if a restaurant plays music in the background, are they profiting from it?
With respect, Your Honor, I think that's a perfect question for Ms. Halligan, because the brief doesn't address that. They're not talking about limited right. They're talking about a categorical property right that says they get to decide. Nobody gets to ever perform their music, they say publicly, but they don't even explain that distinction, unless and until they say so.
Well, they
And that
don't
would apply to
charge, they're not
restaurants.
charging anyone to hear that music when they come into the pizzeria, right?
And that's why Congress created a specific statutory exception for them. This court would have to somehow write in the common law something that says, here's the list of entities to whom this decision between SiriusXM and Flo and Eddie doesn't apply, and here's all the circumstances. And let me add another thing that the DPRA adds, which is
What makes it so difficult? The rule is you're going to charge people to hear it. That is not, that you are somehow breaching their right of performance,
think
unless
the-
you negotiate a price with them.
The difficulty is balancing all of the rights and interests. I don't think this court can create a compulsory licensing scheme. This court can't do what the Congress realized it had to do to protect the interest of performing artists, who are claimed to be, the Flo and Eddie is trying to advance their interests. But in Congress said in the DPRA that the record companies have to share half of the royalties with the performing artists. So they forced that on them, recognizing that just creating the right without doing that would be contrary to the interest of performing artists.
As it stands now, it would apply to whoever owns the rights, which is not necessarily the performers, is that what you're saying?
It's almost never the performers, it's the record companies.
Yeah, I just want to clarify, the rental scheme, that wasn't their argument, that was my argument. So I want to clarify, and it might be theirs, but I was offering it to you that way in terms of my analysis of what was there. And I saw that as something distinctly new and different that was outside any scheme that had been contemplated so far.
Which is exactly why we have legislatures and administrative regulatory
But it
agencies
also
to deal
involves
with the
selling,
problem.
I can pick up my phone and put my little speaker on the desk and play Happy Together 45 times in a row. And you'll all have to listen to it, and I, in essence, own that as long as I rent it, pay the rental service every month. That's entirely different from me putting on WABC and listening to what they have to say, or putting on Sirius XM in my car and say, I want to listen to 70s music, and they play a list. That's a different thing altogether. It involves me the right to choose what's put on, which is the essence of ownership.
Mr. Hecker, let me stop you here, so we'll keep your 5 minutes.
Can I just answer this question?
Certainly. Go ahead.
Which is just, when you purchased it, you paid them a royalty. That's the difference. It's just like, in those circumstances.
So are the
purchasing a
Turtles
record-
getting it?
I'm sorry?
Are they getting it? Are they getting the
Whoever
royalty?
owns the copyright in the composition would get it, just like if you purchased a record.
Thank you,
Thank you.
Mr. Hecker. Ms. Halligan, good afternoon.
Thank you, Your Honor. May it please the Court. Caitlin Halligan for Respondents, Flo and Eddie. I'd like to start with an issue that you raised, Judge Rivera, and then turn to address the questions about the impact of the rule that we're requesting here and these questions about whether it would be readily administrable. First of all, Judge Rivera, you said, and this Court has squarely said in Naxos, that the common law when it comes to copyright protection of sound recordings is flexible. It said that back in Metropolitan Opera more than 65 years ago. It said that the expansive common law protection which exists to protect sound recordings is intended to guard against the commercial exploitation of artistic labor. That's exactly what is at issue
Why
here.
has nobody asserted this right in so many years, if anybody actually thought it existed? I mean, I understand, you know, we go back to when there was this symbiotic relationship, and maybe there still is a symbiotic relationship. I'm not sure that we can tell from this record whether there is or there isn't, whether things have really changed as much as we think they have. But at least since, you know, in the last couple of decades, why would nobody have asserted this right if it was so obvious, if it so obviously existed in our jurisprudence?
A couple of answers to that, Judge Stein. First of all, the record does make clear, and this is a certified question, so obviously it hasn't been fully developed here, but I don't believe there's any question, and certainly Sirius does not, I think, take issue with the proposition that as streaming services have become far more widely used, that at the same time, the sales of hard copies, could be a CD, could be on iTunes, Your Honor, could be, if you're really old-fashioned, to vinyl, that those have dropped significantly and in direct relationship. So I think there's little question but that the economics have changed here. In terms of why this right has not been vindicated, my best guess, and the record doesn't clearly lay this out, is that there was not a significant economic incentive to do that. And the Supreme Court looked at just this question 2 years ago in Petrella. Justice Ginsburg said there's nothing untoward in looking at the very question of the effect of delaying bringing a copyright claim. She says there's nothing untoward about that. There's nothing wrong about waiting to see whether an infringer's exploitation undercuts the value of the copyrighted work, has no effect on it, or even complements it. And so,
Okay, so, but, and, that gets back to whether, in fact, that right exists in our law anyway, and whether there's anything for us to expand or grow on.
Yes.
This seed that.
And let me-
And whether we should, because, even if we think that maybe this is something that's fair, and of course, there's other claims in this case
Yes.
that could also deal with that, but, whether this is something that we should really leave to the legislature, and there certainly seem to be a lot of issues that the federal Congress has dealt with in its decision on post-1972 performance, that how would we deal with that?
So first that question, and then your question about whether or not it's fair and you should do it. Congress was very clear that in enacting the protections for post-1972 sound recordings, and it says this in so many words in the statute, in the 1971 enactment, and in Section 301C of the 1976 Act, it says that it does not touch or in any way affect pre-existing common law copyright. So I think that's clear. In terms of whether you should, I think that Naxos, while it does not squarely involve performance rights, gives very substantial guidance on this question, and here's why. One of the issues that this court had to grapple with in Naxos, which is viewed as the most scholarly, extensive opinion on common law copyright protection of sound recordings, one of the issues was the effect that sale has on whether common law copyright protection continues. Because, as Judge Graffio pointed out in that opinion, for literary works, the sale of that book or play constitutes publication, and at that point, common law copyright protection is over. What she said is...
We're talking about reproduction. I mean, that's a different issue
Well,
here.
I think that the underlying
Piracy
principles...
issue?
I think the underlying principles are the same, because what she said is that, as Judge Rivera pointed out, the common law here is broad and flexible, and its goal is, quote, to keep pace with constantly changing technological and economic aspects so as to reach just and realistic
But
results.
counsel, I think that to me is an issue I'm having here, that I think the common law, you could view it as too expansive, because it took the federal government years and hearings and reports to come up with a scheme that was, you can carve this out and you have AM, FM, and you have these exceptions. We have to paint with a pretty broad brush. And you say we can do all these things, but I think we have to find a right or not find a right here. And one of the things that kind of brought this home to me was your footnote 19 that says, any concerns about whether public entities such as museums or schools or smaller organizations such as college or religious broadcasters would be required to pay royalties are premature and not presented here. In any event, such entities may well be able to negotiate collective licenses for pre-1972 recordings. Is that really the rule we want to make, that schools and religious organizations are going to negotiate for pre-1972
Your Honors, if the court wants to reserve some particular question like that, that might make sense. But what it shouldn't do here
Where would
is-
we leave them at this point if we reserve it? Are they potentially violating your copyright then?
I think that the answer to that is, in part, what's the alternative? What Sirius does here is very straightforward.
The alternative is to let the legislature act.
Well, the legislature has proved very adept at addressing concerns of the sort that you raised. So, for example, one of the points that Amiki makes is what happens to AM/FM broadcasters, and I think Your Honor suggested that as well. They have proved very adept at going to Congress and getting protection. And what Congress has said is, with respect to those kinds of questions, it has looked at that. It did that way back in 1995. Congress looked at this question with regard to post-1972 recordings 20 years ago,
But should
and
we
it found...
be doing that? Should we be looking at pre-1972 AM/FM broadcasts of pre-1972 recordings?
Sure, that's no different than what the court did
But
in
we're
Naxos.
making then a policy decision. No, if we say, okay, we're going to give you a common law right pre-1972, but we're going to carve out AM/FM, isn't that a
I'm not-
decision to
I
make
was-
for
I
the
wasn't-
legislature?
I wasn't suggesting that, Your Honor. What I was suggesting is that if there is ever a circumstance where the plaintiff claims infringement based on playing a song on an AM/FM radio station, then there is every opportunity in that instance, first of all, for the radio station to make the argument that you're laying out, which is to say, when you balance these questions of access, it comes out the other way. But more importantly, with regard to the radio broadcasters, they are well able to secure any kind of protection that they might think is warranted, as their success in doing so, I think, proves. And in addition, these suggestions that they can't comply are belied by the facts. They already pay royalties for musical compositions, and they've been able to work that out without any significant
Well,
impact.
there's only one author of a musical composition, for example.
Yes.
And that doesn't ever change.
Correct.
But the owner of the performance rights can change every day. So, I mean, you
Well-
agree there has to be some kind of mechanism to
I would
figure
take
out-
issue with that, Your Honor, actually. I believe that what's at issue here is there's a sound recording, right? And in the same way that a composer could sell their copyright in a musical composition to anyone, record label, any other organization, so too can a recording artist. And so, yes, some record labels own the copyright protections that the recording artists, whether it's the Turtles or the Platters or Pearl Jam, might have, but that doesn't mean that it's indeterminate in any way. And I would ask you to look at page 55 of our brief. We lay out in detail the ways in which public and private enterprise have risen to deal with these issues. And also, I would ask you to look at...
Perhaps go back to what I thought was sort of the way you were arguing this case, which
Yes.
is we would not now, I mean, it would be an obvious declaration of this right of performance, but it's not as if there's not something that we would be building on. Or have I misunderstood your argument?
Absolutely, Your Honor. I think that that is clearly right. And I think that what Metropolitan Opera and Naxos make clear is that the objective of the common law is to guard against commercial exploitation of artistic labor. Sirius sells songs. The way they do it is you pay a subscription fee, they get $4 billion a year in revenue, 26 million plus subscribers.
So when would there be publication of this performance? At what point is there an intent to put this out in the public domain and we've now given up our right of performance?
Well, I think...
When would that happen?
I think that what Naxos says is that with respect to sound recordings, that the sale is not publication. I suppose that a recording artist could release it into the public domain if he or she said, I want to do that, and it would then not be something that was subject to copyright. But I think that the same rule that applies with respect to musical compositions would apply here. I want to also address this question of intended use, because the key point that Sirius is making in its brief is that post-sale somehow the scope of common law copyright protection can or should shrink to only cover copying and distribution, but not to cover performance. The reality, and this is not contested, is that today that distinction has really been obliterated, because instead of buying a piece of plastic, what consumers like us do is generally to listen to that through a streaming service. And so the intended use is for, when I buy a CD, is for me to go home and put it in my record player and listen to it. It is not for Sirius to do what it has done here, which is to go to Virgin Megastore, buy a CD, and then broadcast it to 26 million subscribers without compensating them a single penny. So all we're saying here is very straightforward. We're saying that when the technology does evolve, as this court said in Naxos, what this
The
court...
federal court has not, or the Second Circuit, they're holding off this question about whether or not they made copies, correct?
They have decided that there was copying, but with respect to the fair use defense that
Okay,
was
all
raised,
right.
they've held off on adjudicating that as well. And that also provides an answer in part to your question, Judge Garcia. There may well be circumstances in which a fair use defense is deemed to be applicable, and so...
Go to your point on Sirius. Is there, and I just ask, a difference between them selling a service, so you are paying to hear this music, versus pretty much AM/FM where advertisers are paying and you're not getting any of the royalties from that either, so you can hear the service? I mean, if somebody's paying the broadcaster, in this case it's a subscription service, but what's the difference?
Well, certainly the payment is much more direct here, but I think that analytically they may be similar. I think that you might be right in that way, and that's why I think that the points that the AM/FM broadcasters raise here, we've attempted to address.
If we do what you suggest, I think you were going to tell us what you think the impact would be.
Yeah, absolutely, Your Honor. First of all, with regard to whether it's feasible to actually manage this, California Federal District Court looked at exactly this question in the course of deciding whether or not class certification was appropriate. We cite that case in our brief at page 55. I would ask you to look at it because it addresses many of the concerns that this court has raised about whether or not that's feasible. So the economic impact, I assume, would be for recording artists substantial because, as Judge McMahon said, why buy a record or download a recording from iTunes if you can easily hear it performed for Sirius for free? So those hard copy sales, no reason for them to go back up.
And what impact would that have on the, on creation of this work? Because isn't that also some of the thread in these cases, the social benefit of the
Absolutely.
creative mind being encouraged?
And for us all to be able to listen to it, I think, as...
But these works are already created before 1972. We're only talking about that.
Yes,
So-
that's right, Your Honor.
Right,
And
so there's no need to encourage that.
Well,
is there?
I think
'Cause the
this-
federal law protects
This court
everything after
said, suggests otherwise in Naxos. What was at issue in Naxos were records that were made in the 1930s. Naxos, of course, was heard by this court 11 years ago. And so that's a much longer difference in time than what we have here with recordings that were made, you know.
Well, I understand that, but in
And
terms
so-
of encouraging creative,
Yeah, so Judge McMahon, I think, got it exactly right. She said that part of how we foster future creativity is to reward past creativity, and that's perfectly in line with what this court decided in Naxos, which is the fact that there were records made in 1930s, and those were what was sought to be protected there, didn't in any way diminish the force of the copyright protection that was made available.
I want to go back to just one point that I made to opposing counsel.
Yes.
Which is, what if I'm proposing something less than that. I view the rental of music and the buying of a CD as pretty much the same thing right now.
Yes.
And that's different from a streaming service, which is like traditional AM/FM radio. And how would you respond to that? What you're asking for is a whole ball of wax.
Well, what we're asking for is for you to hold that when it's used for commercial purposes, that is protected, because that's what serves, if I may finish, that's what serves the purposes that this court said the copyright is intended to protect. I would ask Your Honor to look at pages...
So what would be excluded from that?
Well, certainly, there's no dispute, first of all, that some of these hypotheticals about what happens to someone playing a party in their backyard, no one suggests that that's public performance. That's clearly not covered. AM/FM radio, we discussed. I think conceptually that is covered by a public performance right, but there's every reason to believe that the radio stations would be able to deal with that, both because they pay royalties for musical compositions, and for sound recordings, they've been very able to get exemptions from Congress. There will also be issues about fair use, for example, with educational institutions, but the courts have been very capable of working those out over the years with regard to every other kind of copyrighted
Would that be
work.
our concern, or would it be the Second Circuit's concern?
The fair use issue specifically is certainly not your concern, and I would just ask you in closing to consider the alternatives here. There's no question but that what's happening here is unauthorized use of artistic labor, and there is no compensation being provided at all, and there's a whole lot of
But
profit.
it's only unauthorized because they're now seeking after 100 years to be paid for it.
Your
which
Honor-
they never did before. You don't disagree that it was authorized?
Well,
in the past.
in Waring, which is a case from Pennsylvania, actually, there is a performance right. Also, and I know that my time is up, but Sirius has entered into a settlement to pay already for the vast majority of pre-1972 recordings because it's settled with the record labels. The recording artists individually it hasn't settled with. In addition, California has already found protection under its own statute, and in
Under
Florida...
statute.
It is, but in Florida, Your Honor, and that's because that's what's at play there, although there's some suggestion that there's residual common law protection in California. But in Florida as well, a common law question, this 11th Circuit said they thought there was a good chance that the Florida Supreme Court would find common law protection, same question is presented to you, and like the Second Circuit, it is certified to that court. So this landscape is changing very quickly, and they're asking you to hold off on what is really now a very small sliver of
Well,
those
if we go too far,
recordings.
the legislature can always tell us, no?
Absolutely, the state legislature or the federal legislature, because there's no question but that there's preemptive authority that lies with Congress.
Thank you, Ms.
Your
Halligan,
Honor.
very much. Mr. Hacker?
I don't think, with respect, Your Honor, it's consistent with the judicial function to create a new, literally unprecedented right that even the district court recognized would upend this entire industry, unleash the chaos that's inevitable, and then have the legislature undo the damage through whatever mechanisms the legislature at that point
What in
comes
your
up
view is the chaos? I keep thinking about this, and I can think of some things. I'm sure you've thought of more, and Ms. Halligan was pointing out, that it's not that,
I mean, you have all the settled expectations, the records that were made and sold, broadcast by AM/FM radio for decades without any expectation of any kind of the compensation they're talking about. You have the interest of composers, which are unambiguously injured by this. That was the reason composers opposed the DPRA right, because they were going to get a smaller slice of the pie. You have the interest of performing artists, also unambiguously injured by this kind of performance right, because it reduces the amount of music that's out there. The way a 1960s performing artist makes money now is through festivals, through tours and that kind of thing, and they make money when their music is heard. So Sirius
Is your
XM...
opponent accurate that you have negotiated settlements with a certain large percentage of...
We, Sirius XM, negotiated one settlement with 4 record companies. That's 85% of the rights out there. That expires next year. That doesn't do anything to explain whether we could or will be able to negotiate licenses with the other record holders, nor does it say that other broadcasters, restaurants, DJs, small radio stations will ever be able to find all the rights holders and negotiate with them if this court adopts that kind of common law rule. It says nothing whatsoever about the effects of the common law rule on the industry, which I think at this point have to be basically stipulated to be just the kind of chaos Judge
Is that
McMahon
what we
was
have
talking
to
about.
decide, or again, I asked Ms. Halligan that, do we decide whether the common law protects this right, and then let the Second Circuit sort that out, or do we have to figure out all the details here in this court?
Well, I think it's interesting. The question presented by the Second Circuit was, to be specific, is there a right of public performance for creators of sound recording under New York law? That's the threshold question. And if so, what is the nature and scope of that right? Plaintiff doesn't ever address that second question, because I think addressing it just exposes the fact that it's such a regulatory legislative question to figure out all of the details. The question really here is whether this court, through its common law decision-making, is in a position to adopt the kind of nuanced balance of the various interests that are competing that took so long for Congress to balance.
At one point, we decided comparative negligence should take over from contributory negligence, and most of the sky stayed up, even though there's a lot of thoughts that maybe it would all fall. And it took a lot of courage, I thought, for this court to do that. But should we be too worried about that kind of thing?
I think in any case one has to worry. The medical monitoring case, I think, is a good example of that. The court didn't adopt the independent medical monitoring. Certainly you could have found it in seeds in prior cases, but the court said we don't have a framework for implementing and administering it. Dissenting judges disagreed, but nobody disagreed because they welcomed the idea of a court adopting a regulatory scheme. They just disagreed that it would require that kind of regulatory scheme. Here it clearly does.
How is
as the
it more
DPRA
difficult than
shows.
figuring out when publication fixes? I mean, that strikes me as the harder question than this. This is pretty straightforward here.
Well, it's not a question of whether, one could easily decide that it exists just by deciding it. The problem
Well, I'm
is...
just saying, the courts are able to make that determination, and that strikes me as much more difficult than this.
Because in those cases, the context of Naxos and all the other, and Metropolitan Opera, was whether or not there should be an anti-piracy right, which was a very simple, a very different kind of concern that was recognized by the time this court got to it in Naxos, as this court pointed out. One of the reasons the court was so prepared to do it is that other jurisdictions had done it. The Copyright Office had recognized
But
it
isn't
for
she
so
right
long.
at the heart of it? It's that you're using the performance to profit and the performers, or whoever's holding that right, gets no benefit from that. And that strikes at, that's what the heart of the case.
Not in any different way than has been going on for decades in the industry. That's what every single radio station, when they were playing, and that was the
Not in the
understanding.
same way, that you can't make that argument here.
I think I
It's a
can
very
under-
different world in terms of the amount of economic, financial profit you're making off of it.
Not with
It's
respect to
not like being a DJ in a station, or that station.
But the fact that there's more money, that one broadcaster makes more money than another
But it's
broadcaster
not just
doesn't
more
change
money,
the
right?
nature of
It's
the
her
right.
point. It's not just that you're making all of that money through this particular way of delivering music and the clients that you have. It's also that on their side, they're not making money off the CDs, the records, these other ways that maybe they thought they were an equal
But, Your
poison.
Honor-
Maybe they thought they got enough off of the way the DJs and the stations or anybody would play that music that encouraged the purchase, that they got some money off of it. That's her argument, right? That it's
I understand.
off-tilted that way.
That's right, and SiriusXM promotes that. We're like a radio station, that we're not like Spotify. We're not displacing sales, we're encouraging sales, because more people now listen to music from the 1960s. They
You're
hear it
saying
in their car, and then they want to go buy the record.
You're saying, too, I guess, that these memory tune stations would go out of business if they had to pay royalties on all of the songs that they're playing.
There would be huge economic consequences. It depends on what stations in that position wanted to do, or what record owners, rights owners wanted to do. But to be very clear about a critical point that I think was an error by Ms. Halligan in saying that SiriusXM sells songs. SiriusXM doesn't sell songs.
That aside, though, counsel, are you saying that if we can't determine what the scope of this protection would be, we shouldn't decide that there is any protection?
I think what I'm saying is that, given all of the kind of complex balancing that Congress had to deal with in recognizing the right, and all of the regulatory nuance that Congress implemented in finally recognizing the right, shows why this court should not exercise its authority to extend this right beyond the anti-piracy right that was very straightforward, already well recognized, easily enforced, that had already been recognized in the 1950s. In the 1950s, the Second Circuit recognized an anti-piracy right, and do you know how many industry stakeholders, do you know how many record companies said there's an anti-piracy right, and that includes a performance right? None. They never said it because, and again, a page of history being worth a volume of logic, that's how the industry has been structured now for decades. And with respect to services like SiriusXM, there's no displacement of sales. There's no difference there. There may be some future case involving a different kind of service that this court would want to take on and address. But for this case, for this provider, there's not differently situated from radio stations and how the music industry has been structured, again, for decades, not only without objection from record companies, but with the affirmative declaration to Congress. The reason the DPRA, that they were seeking a performance right in the DPRA, there's no mystery about that. It's not that we don't know. We know exactly. The reason they sought it is they said to Congress, the RIA said to Congress, we need a legislative right because there is no common law protection. That's the understanding, and it shouldn't change today.
Thank you, Mr. Hacker.